the moment the division bell is rung, immediately from the answer and the find that the Speaker orders the Sergeant at Arms to draw the bar. The significance of that means that nobody or no member can leave the chamber, no member can actually enter the chamber, and time freezes. That's the essence. Time freezes, my lord. Now, so in the essence, that a division bell is rung, and until that bar is actually drawn back, that the time that is provided there will be captioned on the date that the bar was actually drawn. And in parliamentary custom, my lord, the office of the clerk reports a resolution on the date that resolution was done. For what my learned colleague is...
But the resolution was done on 21st.
No, my lord. That's where
the voting indicator is a timestamp. The timestamp says it's about 40-something minutes past midnight. It is on 21st.
My lord, it's what we are bringing. What we say time actually stops is the day that the division bell was rung, which was on 20th. And parliamentary divisions actually can extend even to a whole day, because there are instances whereby a parliament will not adjourn until a decision is made. That decision will be made on the day that the division bell was rung, which was on 20th, my lord. So any decision that was made by Senate on that day was actually made on the same time. The office of the clerk...
Just a moment, counsel. Just a moment, counsel. I deal with gazette notices almost daily. And I think as advocates, you also deal with a person who may not understand, especially a gazette notice, who may not understand the arcane English parliamentary procedures. Wouldn't it be better just to date it? And then what evidence do we then have that what the respondent is saying is not correct? Sorry, what the petitioner is saying and what the respondent is now saying from the bar are not correct.
My lord, I do understand the confusion that is there. For purposes of clarity, my lord, I understand where the court is coming from. For persons who may not actually be proficient in legislative processes, the resolution is customarily dated on the date that decision was made. And that parliamentary day, a parliamentary day, my lord, is different from an ordinary day. And you will actually see, even from the standing orders, they define days differently as in the context of a parliament. So, my lord, that means...
I'm familiar with that parliamentary business day, even in Westminster, especially in Westminster, a parliamentary business day can even be a week. That I get. But why then for external communication to the rest of us who know our day ends at midnight, begins at midnight? Why then tell us a decision was made on the 20th? We don't care as a Mwananchi, we don't care about arcane Westminster principles. We just want to know the date when a decision was made.
Thank you, my lord. You have to look at the context. To whom is the Speaker Senate making that communication? To the County Assembly of Men, which is another
the clerk.
Yes,
maybe
the clerk.
I can give you that. I can give you the clerk was speaking to another clerk who may also know the...
For the clerk...
What about the gazette notice for the rest of us?
For purposes of the gazette notice, I let actually my colleague highlight further on that. But my lord, perhaps let me give it to my co-counsel and he can shed more light on it.
Okay. But your time has been off, so you've not suffered any prejudice. Yes. Just a moment, counsel. We'll come in after.
My name is Meru.
Yes.
My lord, the way I understand it is that a parliamentary day is not an actual calendar date. You are agree on that?
Yes. A parliamentary business day is not the same as a calendar date. Yes.
And the way I also understand it is that the resolution, which is the resolution of Parliament, is dated on the parliamentary day on which that resolution was made, such that the communication to the external world, of course, Council has qualified the one to the Assembly, but even the communication, there's a notice that was published in the Gazette. That is a communication as well. And I think there would be a discrepancy if the communication to the clerk was to bear the parliamentary business day on which that resolution was made, but the Gazette notice that is published for consumption by the public bears the calendar date. So for all intents and purposes, my Lord, the way I understand it is that a resolution, whether it is being communicated to Parliament, to another legislative body, or even for the consumption of the public, is dated on the parliamentary day on which that resolution was made.
I'm looking for that Gazette notice. I've gotten a little bit turned around. Councillor Ngoya, which volume is it in? So, respondents replying affidavit, it's an extra. So towards the end. Sorry, what page number?
In our volumes,
Yes.
of course I don't have my computer.
I was just page 2,207. 2,207 of the experience.
Page 2025.
Let's get to experience. I have this one in my brain.
Which volume number of the respondents is that?
I don't have all the volumes to do last week.
Because the last volume I have is a volume number 4 for the respondent.
Page 2045, they were sequential.
Yes, mine ends at 1736. I suspect there's a volume number 5, which I don't have in hard copy. Perhaps. No, theirs would have a. These are only for the petitions. Does anyone have a copy of that Gazette?
I have a copy.
Yes, that's all I need to see.
I want to make a comment on what my colleagues have been saying on another.
No, this is not the Gazette I'm looking for. I'm looking for the one dated 20th of August. Don't worry, I did look at your notes, so I don't have advance notice of what you're going to submit. The Gazette notice dated 20th August. Yes, I'll accept a laptop. First line, because this was my recollection. First line. That's why I separated the clerk speaking to the county assembly and this other one. It is notified for the information of the general public. Then that and gross misconduct gross violation of the Constitution, gross misconduct, abuse of office, dated the 20th of August 2024. Thank you, Council.
I just like to make one comment, by the way.
Yes.
You know, your question to Mr. Mukele was simple. The other colleague who expanded the scope of that question. The question to me was whether, as I had it, whether the clerk at any place in his supply affidavit explains why he dated his tweeting.
Yes.
And the answer, as I got it from Mr. Mukele, is that there is no explanation of the clerk. So that, I think the answer is there. The only challenge is when my colleagues now begin explaining from the bar about parliamentary tradition, first without asserting the source of that expertise.
They said AXA in...
But if we have to take them for their word,
yes.
then one will have to look at the petitioner's volume number 1A,
yes.
page 367, which is Parliament's own answer.
No, that is not in doubt,
Yes.
Council.
So the Parliament's own answer shows that Parliament acknowledges actual times and actual dates. So this is a parliamentary own document. If my colleagues want to tell me that the clerk of the Senate communicating with the clerk of the county assembly has some understanding of parliamentary time, there will be no clearer understanding of parliamentary time than the Senate capturing its own records in its own answer. And they tell us 21st August 2024. That's the understanding of their time. And more importantly for me, there's then the parliamentary business, that's the debate and resolutions.
Yes.
Then there are the administrative communications of those decisions. Those are two different things. In this court, for example, my lord, you will make an order on a particular day. That order will permanently remain made on a particular day. But the moment the registrar is extracting that order, he will communicate the date when that order is issued, as and when we get along. So that becomes critical for communication to the public.
So I've not recorded any of that. My question, Councilor Mukele, is the Gazette notice begins, it is notified for the information of the general public. And then it's dated 20th. The purpose of the date, to my understanding of a Gazette notice, is to say the date it was issued as such, and it is for the general public. Can the general public then be expected to know these arcane Westminster traditions? Or can we then say that that decision was made on the 20th, calendar date 20th?
Your Lordship, I still maintain the decision was made on the 20th. In fact, Your Lordship, if you looked at the specific allegation, was that the debate took place on a date not gazetted.
Okay. All right. So let's leave that. Let's leave that there. The only thing I've recorded for all that, it's just so that I'm settled in my mind. A division is only called when it is a matter that affects the county, so that we go into delegations. That was the last thing that I recorded.
Yes. Your Lordship, just to pick up from where I left,
Yes.
that the delegation means that every senator in charge of a county delegation has to vote, Your Lordship.
Yes.
And remember, Your Lordship, that happened for the second division exercise, the one for voting on the impeachment, as well as voting on the debate for limitation of time, Your Lordship. Your Lordship, inevitably that means a lot of time is spent on that exercise, Your Lordship. And in that understanding, Your Lordship, and on the basis of the rules that I mentioned, Your Lordship, then interruption can only occur after the business of the day is complete, Your Lordship. Your Lordship,
You have about 20 minutes. If this is not a very controversial issue, that they will spill over into the next day, perhaps you can use your 20 minutes or so on something that is in contest.
Your Lordship, just to summarize that point,
Yes.
if I annexed the Gazette notice, that is 16th of August,
Yes.
and it specifically says that the sittings shall be held on Tuesday, 20th August 2024, commencing 9 a.m. until the conclusion of the business of the day. That is in the Gazette.
That is not in context. In
So,
context.
Your Lordship, let me quickly move to the next point that had an issue, Your Lordship. I'll go to the question of sub judice, Your Lordship.
Yes.
Your Lordship, the simple submission under sub judice or any matter for that fact that calls the attention of the Senate is that it must be raised as a preliminary issue before the Senate, Your Lordship. This is under Rule 14 of the Impeachment Rules, Your Lordship.
Yes.
Your Lordship, just by way of example, Your Lordship, the County Assembly raised preliminary issue, Your Lordship.
Yes.
Your Lordship, if you look at the Hansard of August 19th, 2024,
Yes.
at page 13, Your Lordship, of the I'm just trying to confirm whether it was the morning session. Of the morning session, Your Lordship.
Yes.
There is a part where Mr. Ndego Njiru, counsel for the County Assembly, makes the following remarks, Your Lordship.
Yes.
Mr. Speaker, sir, I seek your guidance and leave before we make our address on Rule 10 of the Standing Orders and Article 50 of the Constitution in respect to a preliminary issue that has arisen and Rule 14 as well, which states that any preliminary question or issue raised by the County Assembly or the Governor shall be argued for not more than 30 minutes unless the Speaker otherwise directs the Lordship.
Yes.
Your Lordship, you've been told that attention was drawn. In fact, let me use Mr. Solongoya's words. I hope I quote them right. That was drawing attention by way of a letter, Your Lordship.
Yes.
Your Lordship, these rules were served on all parties, both the County Assembly and the Governor's side, Your Lordship. On 14th of August, Your Lordship, I've done it in my narration of the facts.
Yes.
Your Lordship, those rules are the rules that govern this impeachment, Your Lordship.
Yes.
And in any case, Your Lordship, this is not the first time that the Governor is coming for the impeachment. He understands these procedures, Your Lordship, that a preliminary issue will be raised, Your Lordship. So when that preliminary issue was raised, I'll just quickly go to the next page, which is page 14, after the page 13 I made reference to. That is when counsel for the Governor, my senior Mr. Elisha Ngoya. Now, this is, I'm looking at the Senate Hansard of August 19th of 2024. Now I'm going to page 14, the morning session. Your Lordship, when counsel was given the chance, he actually just responded to the issues raised by the County Assembly, Your Lordship. He never made any mention about the sub judice and all of those things, Your Lordship, for purposes of the Speaker making a determination as a preliminary issue, Your Lordship.
Yes, we have different references which is having, because page 14 that I have, we have a page 40. We have a certified copy of the answer here. The page 14, nothing fits for that, anyone is subject. Because if you look at volume 1A, which is a certified copy of the answer, so just check. Yeah, I'm there. That's page 14 now of the bundle. But I'm for that. I'll put an affirmation of page 14.
As I was continuing, counsel does not raise any issue for purposes of it being considered by the Senate, Your Lordship. And Your Lordship will bear in mind that the question of sub judice is not a question for the respondent to determine on his own, Your Lordship. It is a question to be put before the House as a preliminary issue, Your Lordship. Now, Your Lordship, that having not been mentioned, towards the tail end, of the proceedings, and particularly on the governor's closing submissions, is when counsel raises the issue of sub judice at the tail end of the proceedings. At length, on Friday, counsel brought to your attention the exact words he used, Your Lordship. But what you are not told is that happened at the tail end of the proceedings, Your Lordship, at the closing submissions of the governor, Your Lordship. Equally, Your Lordship, you've been told that Senator Halwale raised a point of order about the issue, Your Lordship. But Your Lordship, that issue is being raised at the time when the Speaker has put the question, Your Lordship. And Your Lordship, the rules of the Senate particularly Standing Order 96 of the Senate Standing Orders, provides that no senator shall speak to any question after the question has been put by the Speaker, Your Lordship. And in the same regard, Your Lordship, you will have time to look at the answer for that particular moment. Yes. What happened is that the Speaker actually ruled the said senator to be totally out of order, Your Lordship. The rules do not allow that, Your Lordship. So then what does that mean, Your Lordship? If you raise the issue of sub judice at the tail end in your closing submissions, Your Lordship, because having not raised it at a preliminary stage, Your Lordship, so that the Speaker rules on it, it simply means that as part of your closing arguments, you raise that issue, Your Lordship. So that means when senators are voting, then they consider it as part of your general submissions, Your Lordship. So if they find to the contrary, or if they vote otherwise, Your Lordship, then how do you come and say that this issue was raised and was not considered, Your Lordship? Is it an appeal? What exactly is it, Your Lordship?
You have 10 minutes.
Yes, Your Lordship. I will not speak much to that issue. I will quickly move to the substantiation of particulars, Your Lordship, whether the threshold is met. Your Lordship, from the first of it, I was surprised when my senior on Friday asked you to conduct both a procedural and a merit review of that decision in the Senate, Your Lordship.
Yes.
Your Lordship, a merit review of that decision means that this court is going to sit as the Senate. That this court may substitute its own decision with a decision of the Senate, Your Lordship. I submit that that is not what the law provides.
Yes.
Your Lordship, by way of example, the law only requires, and I'll just avoid quoting the laws, that the allegations are substantiated. That's section 33 of the County Government Act. The word is substantiated. And in any case, Your Lordship, even one ground, the substantiation of one ground, is enough to impeach the governor, Your Lordship. Your Lordship, there is no evidence of bad faith or ill intention on the part of the Senate. And in this regard, I make reference to the Supreme Court case in the Mike Sonko decision, where the court actually found that there was no evidence of a predetermined outcome, Your Lordship.
Yes.
And Your Lordship, just to put it into perspective, I am wondering what will happen one day if now the Senate acquits, and maybe at that time the Assembly comes to you and tells you the Senate follows the Senate decision to acquit and say that the governor should have been impeached, Your Lordship. And then ultimately maybe this court is going to make a finding that yes, the governor now is impeached at that point. It would be absurd, Your Lordship. And that is why a merit review of the decision is not open to this court.
Yes.
Just briefly on, I think I had said last, but let me just do one last issue, with your permission, Your Lordship, that whether there was a valid court order, I won't go into depth about that, but my submission is that at the point the Senate was considering this impeachment, there was no valid court order, but I will let the interested parties speak more about that. And Your Lordship, barring any clarification,
Yes.
or questions that you wish to put to me,
Yes.
I would like to conclude my writing at that point.
Thank you. I do have 3 questions for you. You finished with 7 minutes to spare, which I will highly encourage. Do you have a copy of the Senate standing orders?
Yes,
Standing order 103?
yes, I have it, Your Lordship.
So what is standing order 103 about?
Your Lordship, standing order 103, in essence, is,
Marginal note?
yes, matters sub judice or secret, Your Lordship.
So standing order 103 begins by saying, subject to paragraph 5, no senator shall refer to any particular matter which is sub judice or which by the operation of any written law is secret. A matter shall be considered to be sub judice when it refers to active criminal or civil proceedings and the discussions of such matter is likely to prejudice its fair determination. And then it proceeds onwards. What should I make of standing order 103 vis-a-vis, because you had not mentioned standing order 103, that's why I raise it, vis-a-vis the others that you mentioned, including the impeachment rules?
Your Lordship, I mentioned it in my submissions, I just didn't highlight on them.
Yes.
But I will perhaps send the court directly to standing order 103.5, which is in my submissions. I thought.
Yes.
Yes. Your Lordship, it provides that notwithstanding that standing order, the Speaker may allow reference to any matter before the Senate or committee, Your Lordship.
Okay, so that was my second question. You said that preliminary issues, let me read what I recorded. Preliminary issues are not determined by the Speaker, but rather the House. But then standing order number 103.5 seems to say something different. The Speaker may allow reference to any matter before the Senate or a committee. So an exception to sub judice. So it appears that it was the respondent's role to determine whether to allow the objection.
Yes, Your Lordship, the question here is, I think the time, because the time when this issue is raised. Remember, Your Lordship, when in the application of standing order 103.5, this is after the matter is before the Senate, Your Lordship. When the matter is at the floor, where the Speaker has to make a ruling, Your Lordship, it has to be raised, not in his private quarters or capacity,
Yes.
receiving a letter, and then proceeding to decide that yes, this issue. These are questions for the Senate, Your Lordship. And the Speaker is empowered in that sitting, Your Lordship, not in his office or somewhere else, to make that ruling when the issue is raised before the Senate, Your Lordship. That is our submission.
So the last is where the court situates the impeachment rules. Are they part of the standing orders, subordinate to the standing orders, parallel to the standing orders?
Your Lordship, it is part of the standing orders. In fact, if you look at the rules,
Yes.
in the schedule, for instance, I'll refer to second schedule, which provides for the rules of the standing orders, Your Lordship, which provides for the rules of procedure for removal of
the president
by impeachment.
Yes.
It actually quotes standing order 78-9.
It's a wider question. What happens generally? So let's just look at an act of parliament.
Yes.
What happens if the schedule and the substantive section of the law where it derives its power from, its authority, are at cross purposes? So can the schedule derogate from 103?
I do not think so, Your Lordship. In fact, in my view, the same way we interpret the Constitution,
Yes.
the document should be read as a whole, with no single provision trying to host the other or sort of circumvent the other, Your Lordship. Our position is that these rules must be read as a whole, Your Lordship, not in isolation.
Thank you.
My Lord, perhaps I can add some context into that.
Yes.
My Lord, I don't know the exact provision of the Senate standing orders, but given a chance, I can refer the Honorable Court to it. The rules generally become that any rules made, there are committees in either the County Assembly or the Senate that deals with rules. Any rules made must be appended to the standing orders. So the rules themselves, they are an intrinsic part of the standing orders. They are never read in isolation of the standing orders.
So the County Assembly was to have 1 hour as well. Just a moment, let me reset the time. Yes.
Yes, my name is Meru Njarene. I begin from the first issue that just to address what my landlord, Mr. Ukenda, submitted on. The issue of the orders that are sought in this petition, Lord.
Yes.
You will note that the orders that are sought seeking to quash the decision of the Senate. Then there is order number H, prayer number H, a declaration that the Senate, here the Senate is not a part in these proceedings, my Lord. And Council referred you to the other prayers where declarations are equally sought against the Senate and some even referring to the Senate. But the point I want to make is that contrary to what I think the petitioner is an authority referred to previously.
Yes.
There is Speaker of the National Assembly versus Center for Rights, Education and Awareness, which is a court of appeal decision.
Speaker of the National Assembly versus?
Center for Rights, Education and Awareness. It's a 2019 decision, my Lord. In that decision, my Lord,
Yes.
the speakers of both houses, that is the National Assembly and the Senate, have been sued. And I remember my learned senior, Elisha, was submitting on this issue
Yes.
extensively, and his position was that when the Speaker of the Senate is sued, it ought to be taken that equally the Senate is sued. That authority, my Lord, is distinguishable from the matter at hand. Because if you look at paragraph 17, if you look at paragraph 17 of that decision of note,
Yes.
all the orders that were granted by the High Court, that is Justice Meru Njarene, were orders directed to the Speaker of the Senate and the Speaker of the National Assembly. There were no orders issued against the Senate because the Senate was not a party on that matter. Moving on, my Lord, I think it is important that I point out the documents that the Assembly will rely on.
Yes.
My Lord, we filed a replying affidavit, the fifth interested party replying affidavit sworn on the 16th of January of 2025, together with the index of annexures, that affidavit.
Yes.
The submissions dated 11th of February of 2025, together with the list and bundle of authorities that are filed alongside the submissions, my Lord. And at this moment, my Lord, I seek the assistance of your court assistant. That is the entire bundle of documents that the Assembly will be relying on. Perhaps they can be distributed for the desk for ease of reference.
Yes. So that when you go back to your respective clients, in case they ask you why Mwamuye J is taking 21 days to write a judgment, perhaps you can mention Mwamuye J will go past through more than 10,000 pages. It is more than 10,000 pages.
You see what I agree, my Lord.
Yes.
My Lord, I will first begin by explaining the impeachment process. My Lord, the impeachment process begins with collection of signatures at the Assembly.
Yes.
Standing order number 65 of the County Assembly Standing Orders. And this, my Lord, is
Standing order number?
65, specifically 65-1 of the County Assembly Standing Orders,
Yes.
which are to be found on pages, the specific page is 1678, page 1678, in the annexure marked as JK41B.
Yes.
My Lord, once the intended mover collects the directions, that is that of the members of the Assembly, and the Speaker approves that motion, it is then tabled on the floor of the House.
Yes.
And pursuant to Standing Order 65-2, the mover gives 7 days notice calling for the impeachment of the governor. Pursuant to Standing Order 65-3, my Lord, upon the expiry of the 7 days,
Yes.
the motion is placed on the order paper and disposed of within 3 days. So, my Lord, the entire time that the County Assembly has, right from filing that motion with the Office of the Clerk, to giving notice, to consideration, and passing a resolution,
Yes.
either in support of or to defeat the motion, is 10 days. 10 days is the maximum amount of time that the County Assembly has. That upon approval, if that motion succeeds at the Assembly, with the 2/3 threshold,
Yes.
that resolution is communicated to the Speaker of the Senate within 2 days, pursuant to Section 93 of the County Government Act of Law.
Yes.
And the Senate convenes, the Speaker of the Senate convenes the Senate to consider that motion.
Yes.
So, my Lord, the role of the Assembly is to initiate the impeachment process.
Yes.
My Lord, the decision in Martin Ambora, appeal number 21, it is in our list and bundle of authorities at page 111, spilling over to 112.
Yes.
This decision, my Lord, by the Court of Appeal, finds that the role of the Assembly is to initiate the impeachment process.
Yes.
And my Lord, the candidate Court of Appeal, there are 3 sequential steps to be followed. First is initiation of a motion to remove the governor by a member of the County Assembly. Second is consideration of the motion and a resolution by 2/3 of all the members of the Assembly.
Yes.
And that the Speaker of the Assembly is to forward the County Assembly resolution to the Senate for hearing of the charges against the governor. So, my Lord, what is the role of the Senate? We submit that the role of the Senate, my Lord, pursuant to this decision, is to hear the charges against the governor. Section 33 of the County Governments Act, my Lord, and Rule 2. Rule 2 of the Senate Rules of Procedure
Yes.
equally provides that the role of the Senate, my Lord, is to investigate the charges and to determine whether the particulars have been substantiated. Once Senate considers the impeachment charges, my Lord, and makes a resolution,
Yes.
the dispute might find itself to court, as we have found ourselves, my Lord, before you. The question that then arises is, what is the role of the court?
Yes.
My Lord, we submit that the role of the court is to review the processes at the Assembly and the Senate to establish whether individual rights of the petitioner have been violated. Ordinarily, my Lord, that would be the role of this court. But my Lord, this is no ordinary petition.
Yes.
Because the petitioner, my Lord, does not complain about the processes at the Assembly. My Lord, I'll refer you to the further affidavit.
Just a moment.
Can I proceed, my Lord?
Just a moment. Yes, proceed.
My Lord, I refer you to paragraphs 91 and 92 of the petitioner's further affidavit.
Yes.
My Lord, I'll read verbatim what the petitioner says. Imperative to note is the fact that the amended petition does not at any point make any allegation against the County Assembly of Meru, and neither are there any relief sought against the fifth interested party, which is the County Assembly of Meru, as per its assertions and the paragraph of its affidavit. That paragraph is omitted. A paragraph 92, my Lord, the petitioner goes on to say as follows: I could not help to note that the 4th, fifth, and sixth interested parties, through their responses, are framed a new cause of action against them and sought to respond on the very extraneous issues unrelated to the issues raised in the amended petition. If it comes to the next page, a paragraph 29, the petitioner deposed as follows. The notable fact and distinction is that the cause of action in the instant petition arose at the Senate and not at the County Assembly. My Lord, what is this court supposed to make of those words? Whose depositions by the petitioner under oath?
Yes.
Lord, the petitioner has made no allegations against the Assembly. The petitioner seeks no reliefs against the Assembly. The petitioner does not complain about the processes of the Assembly.
Yes.
And even faults the Assembly for responding on what she called extraneous issues that are unrelated to this petition. So, my Lord, as you exercise your role, as you sit as an arbiter over this matter,
Yes.
we submit, my Lord, that your role is only limited to reviewing the processes at the Senate and not at the Assembly.
Yes.
My Lord, the province of this court, as we are told, is Martin NGABANA, and thank you very much, Dr. Koti, my Lord.
Yes.
Martin NGABANA, page 112, paragraph 32, tells us that the province of the court is solely to decide on the rights of individuals and not to inquire how the County Assembly and Senate perform duties in which they have discretion. Well, in our case, it is only the Senate, not the County Assembly, because there are no allegations. The petitioner complains not against the County Assembly, and therefore your role is only limited to the procedure at the Senate. Well, if you look at the amended petition, who are the parties? It is Honorable MWANGAZA's petitioner by the Speaker of the Senate. The County Assembly is a party, my Lord, I believe this is uncontested. We became a party on account of the oral application for GWITA removed on the 18th of September, on the 18th of December, I'm sorry. Well, if you look at the authority, at the decision in Martin NGABANA, Civil Appeal number 21, is appearing on page 104 of the Assembly's list and band of authorities. The County Assembly was the 6th respondent.
Yes.
If you go to Sonko, my Lord,
Yes.
just a moment, my Lord. The decision in Sonko, my Lord, the County Assembly was the third, the Nairobi City County Assembly was the third respondent.
Yes.
The Speaker of the Nairobi County Assembly was even sued as the second respondent. Unlike in these two cases, my Lord, the petitioner has no cause of action against the Assembly, and therefore, my Lord, it must be that in exercising your jurisdiction,
Yes.
the petitioner has confined you to the processes at the Senate.
Yes.
My Lord, what is the review jurisdiction of this court. What is the remit or the extent of the review jurisdiction by this court? Our position, my lord, is that the jurisdiction of this court does not extend to a merit review of the decision or the resolution by the Senate. For now, we are not bothered with the Assembly, just with the Senate. Because, my lord, if this court, my lord, was to conduct a merit review of the decision of the Senate, this court would be supplanting its own decision, substituting the decision of the Senate for its own.
Just a moment, let me take your time off. Let's go to the amended, it's going to be amended petition, and we can look at the prayer. I'm interested in prayer number I.
Prayer number I, I'm there, my lord.
Yes, please.
Yes.
An order of Sachi Orarai, it's been spelled the way we should pronounce it, to remove this honorable court and quash the decision and or resolution of the Senate made on 21st August 2024, resolving to remove the petitioner from office by way of impeachment. That was initially a judicial review prayer, remedy, relief. Then it was constitutionalized. Can that be issued in a procedural case?
Indeed, my lord.
So,
if I can explain, my lord.
yes.
This court, in reviewing the procedure at the Senate, if this court was to find, my lord,
Yes.
that the rights of the petitioner were violated,
Yes.
by way of example, if this court was to find that the petitioner was not afforded an ample opportunity to present a defense, that's a violation of our right to fair hearing,
Yes.
this court can quash that resolution.
So let's look at the previous prayer, which is prayer H. It is declaratory in nature, though.
A declaratory, that is order number H?
Yes, H.
Yes.
Please read it.
A declaration that the Senate, in its evaluation of the impeachment proceedings before it, failed to properly assess each of the specified grounds and determine if they collectively or individually constituted gross violation of the Constitution, warranting the removal from office by impeachment of the governor. Hence, the resolution of 21st August 2024 does not meet the threshold for impeachment set out under Article 181 of the Constitution, hence the same be and is hereby certified.
To the fifth IP's mind, is that merit or is that procedural?
That is merit, my lord, and that is why we invite you.
Okay, so your time is back on.
Yes, my lord. My lord, those two prayers, foremost, are sought against the Senate, which is not a party. I think it is important to clarify that. Two, this is an invitation, my lord, for you to look into the merits of the decision by the Senate. An invitation we humbly urge you to decline. My lord, we find strength in that submission, my lord, in Martin Lega Wambora, page 112 of our submissions, my lord, our list and panel of authorities. The province of the court is solely to decide on the rights of individuals and not to require how the county assembly and senate perform duties in which they have discretion. We find further strength, my lord, in the Sonko decision at paragraph 112, where the Supreme Court stated as follows, and I quote, likewise, in Justice Kariuki Martin and Renata versus Martin Meru Njarene, Supreme Court petition number 32 of 2014, this court signaled that it would be reluctant to question parliamentary procedures as long as it did not breach the Constitution, and that the mandate of the courts is restricted by the doctrine of separation of powers to deciding on matters of individual rights and fundamental freedoms, and not to inquire into how the County Assembly and Senate perform duties in which they alone have discretion, or to review the merit of the decision by the County Assembly and Senate to impeach the government. We submit, my Lord, that you are guided by those two authorities.
Yes.
My Lord,
I will record you are bound.
indeed, my Lord, bound on this word.
Yes, proceed.
My Lord, in exercising that review jurisdiction,
Yes.
to relook or to review the processes at the Senate, we submit that, my Lord, in that very limited review that the petitioner has confined you to, and which, for the record, we have no problem with, this court, my Lord, should also be aware
Yes.
that the role of the Senate is not to reassess the procedures at the Assembly.
Yes.
Such that, my Lord, all the instances where the petitioner faults the Speaker of the Senate or even the Senate for not correcting what in the petitioner's views were errors at the Assembly, my Lord, we submit that that is not the authority of the Senate. The Senate has no authority to review the procedures at the Assembly. Perhaps that is why, my Lord, in that sequential or hierarchical separation of the distinct jurisdictions of all the three bodies, this court ultimately has the power to look at the procedures at the Assembly. The Senate does not have that power.
So let's assume that the County Assembly, let's give a situation that would never occur.
Is the time closed, my Lord? Can I have a-
Yes, it is. So the County Assembly does not, there is no mover, they just go straight to the end. There is no vote, no nothing, just the Speaker of the County Assembly forwards the decision to the Speaker of the August House. He's saying that, and then it is raised as a preliminary issue. Are you saying that in that instance, the Senate would not be able to say there was such and such procedure established by the law and by the County Assembly's own standing orders, it was not followed, breach of procedure, we are not hearing this, we reject it?
My Lord, my understanding is one,
Yes.
that any grievances that ought to be raised at the Assembly cannot be taken on appeal. Such that, my Lord,
Yes.
Senate does not sit on appeal of the decision by the County Assembly. The role of the Senate under Section 33, and also I believe Rule 2 of the Senate Rules of Procedure, is to investigate the charges and to determine whether the same have been substantiated.
Mama ntuko yothe nyantokaira mwathani nari mbere bundirambie kwendia sabuni ndetora ndakoroga mutungi jumwe na ninkoroga sabuni nyingi muno
muntu akebsi yagosa nontu twaina karum kanini muno gantaka atwirire muntu au nibwambagiria
ndambiriria tent imwe ya 50 sita na kaka keta wakazibo aranda umere ni araja
muntu akeza bure nikiwezera ngugina icharuko ngugia kwana yaruko lakini nigufida antu baba ingi
human resource to are doing things right the first time you do them.
Nditho twinana bara tu support akuma primary mwaka university. Kagitene kaka twinana over 8,000.
Ana kuruki wena.
8,000. Ngirimu.
Ekuru ito baguraira matangi. Gete njachi on the china stima. Toka make sure mo ito class 8 on the and right.
Kuthithia special needs education it's a calling. Ukagwa mwana ora nakwenda attention na nabwirite kumenyerwa.
Secondary ndathoma ota baria bange nkine etikiria ati niyo ntena wathe no tunenkurutha buria antu baria bange baruthaga
kana geta uyu
ya ithatũ twathoma manta kusumbi mirire turoito bateri kunyua ncho bintu gocio yari
makenaga nkwire kwirutaniriga antu kamana wawira wene akwaya gacuru ndang'ang'anire mwanka ndekira ruji
Mobango Juankatha Cieto ureterine Yetu Sacco niyezanaga utungata kiria biashara gukurukira gukiria biashara uguraniri bwa miunda na ngare na kinya uthurania bwa mbesha nja gwaku na kiri biashara. Yetu Sacco, your success, our pride.
Leta driving license. Ala, gari ina makosa bwana. Naona hii gari ina makosa. Ina makosa kabisa. Ala. Na yeye ni muzikirani hapo. Hebu ngaza bodi kidogo. Oya kidogo tena. Hapo. Tunaulizaje? Ni station gani hapa bana? Tunakuuliza ni station gani bwana? Angalia hiyo mbavu. Unajua nafikiria tunampeleka kwa station na tunataka kujua ni station gani.
Meru FM. Unundune ija weruni. Iji ni Meru TV.
The judiciary is no longer serving justice, but serving judice. That judice is a concept popularized by senior counsel Ahmed Nazir Abdullahi in social media, signifying judicial corruption. It's acquiring a term of art status.
She's calling on the head of the judiciary to come out and clean the mess, saying the judiciary is unclean, stinking. Citizens have lost confidence with this arm of the government. That's what she's saying. I'm making out an argument, my lord, that for a party who is actively before you, these things are not being done by some stranger out there, in which case we can ignore. For a party who is actively before you to make these comments, not just against the judiciary generally, but in reference to a matter where she is involved, she has crossed the red line. She was here in the morning. She left when she knew that we are bringing up this issue. She was in this court physically in the morning. She left. And she knows we're going to have this issue. We urge that you direct her advocate to bring her back here, either now or at another time that the court will elect, for her to show cause why you should not punish her for contempt of court. I respectfully submit.
Possible overlap between the two cases.
My lord, the point is,
yes,
the question whether there was a conservatory order stopping the impeachment motion dated the 1st of July 2024 that was approved by the Senate. That question is before you for determination.
we canvassed this on Friday at quite some length.
Indeed, my lord.
Yes, I've switched off your time so that we can pick it up, but this time we'll not go to the petitioners.
Yes.
I'll just deal with the persons who have opposed.
Yes.
So there's a ruling of the High Court sitting at Meru dated 13th February 2025, which has found that there was an order capable of a contemptuous acts being committed.
Yes, my lord.
Isn't that the end of that? I cannot sit in review of my brother.
It is not the end of it, my lord.
Yes.
And we will seek to persuade you, my lord, that one, we are not inviting you to review or to sit on appeal.
Yes.
Of that ruling by your brother Justice Edward MBERE.
Yes.
Secondly, my lord, that ruling, the gravamen or the gist of that ruling was on the question of contempt.
Yes.
That ruling does not determine the question whether there was a conservatory order. That is an issue that question was brought before you for determination by the petitioner. So the question whether there was a conservatory order has not been decided. When the court in Meru decided on matters of contempt.
I've had the benefit of reading that decision, and you also have as well. Your time is off. So my brother sitting in Meru found that the act of withdrawing the motion and then refiling another motion, the motion that led us to today, was an act of contempt. Is that found within that ruling?
Yes, my lord.
So when you submit to me about that, aren't you asking this court to re-examine a factual finding that was made by Meru?
My lord, the finding, and perhaps that is where you don't seem to agree, is the finding is on the issue of...
No, I've not yet made up my mind. That's why your time is off. I want, because it's a very, very grave thing for myself to purport to re-examine something that my brother or my sister has already determined. So I want to be very, very careful. I want to know that I can confidently do it. So just explain the distinction between what happened in Meru and was determined in Meru and what is before me.
Well, the ruling in Meru
addresses
the issue of contempt. And the issue that was before court, the application that was filed by the petitioner, was the application dated 1st of August, with somewhere in our bundle of documents.
Yes.
An application seeking, one, to cite the...
Let's go to that application.
Yes,
I can see yours has nice tags. If you ever have another impeachment or any other matter before me, I also like tags in my documents.
There is an application dated the application begins on page
256.
52.
256 is where the motion begins.
Yes, 256, my lord. This is the first application, my lord.
Yes.
Seeking a conservatory order against the respondent, which is the County Assembly of Meru, suspending the debating, considering and acting upon the motion. The wording, my lord, is upon the motion.
Yes.
For removal of the applicant from office to impeachment. This prayer, my lord, was not expected. It was never granted.
Yes.
The order, my lord, that is subject to that ruling, the ruling of 13th of February, is a ruling where I think Mr. MWANGAZA was referring to that. He was reading relatively where your brother, Justice Kassan, held the upshot of this ruling. That was the ruling that was subject to the application for contempt.
Yes.
Yes. This application, my lord, the application on page 256, the motion on 257, my lord, the prayers, is on the motion dated 15th of July.
Okay, so go to 415 of the same bundle.
415, my lord.
Yes.
And then, my lord, this is the subsequent application.
Yes.
On the motion specific to the motion dated 31st of July of 2024.
Yes. So there was a prayer number 5 to that.
Yes.
That pending the hearing and determination of this application inter partes, this honorable court be pleased to issue further conservatory orders against the respondents, prohibiting them from debating, considering, deliberating on the notice of impeachment dated 31st July 2024 or in any other manner in whatsoever nature reintroducing any impeachment notice against the petitioner applicant.
Yes, my lord.
Yes.
My lord, those two I should call them sets of conservatory orders, on 256, 257, and 416, specifically prayer number 8, those conservatory orders were never granted. Today, those prayers have never been granted. They were sought ex parte, orders were never granted ex parte. The petitioner has not furnished you with any order, conservatory order, that was granted ex parte, or even upon the party's hearing. No such orders were granted.
Okay. Let me understand why you're dwelling so much on the ex parte aspect of it.
Well, I'm not just dwelling on the ex parte aspect of it. What I am saying, my Lord, is the orders, whether ex parte or inter partes, the conservatory orders, whether sought or prayed for ex parte or inter partes, were never granted to this day.
So what did my brother, Reddy J, find was the contemptuous act?
The contemptuous act, my Lord, was with respect to the ruling that was given on 24th of July.
Yes.
Which
halted any...
Perhaps you can go to that ruling, my Lord.
Yes.
It's on page 294, 298.
So I'll read the last two paragraphs of that ruling. This court must also take note that this is the fourth time the petitioner is facing impeachment. The other three attempts failed. It is in the interest of the public that the petition is decided at this stage to pave way for future smooth process, because so far resources and judicial time has been spent. The upshot of the above is that the impeachment process is halted pending my ruling, and since this is a matter of the public interest, the rulings, PO, interested parties and main petition will be delivered on Monday, the 29th day of July, 2024, via email to all parties. There was then a subsequent deferral and a fresh fixing. Yes?
My Lord, my submission in that regard, my Lord, is that ruling is one specific to the impeachment motion to the 15th of July. It is not, there was no grant of a conservatory order in that ruling.
I have read that ruling. You've read that ruling.
Yes, my Lord.
The central part is this. The upshot of the above is that the impeachment process is halted. Not a specific motion, which is why then, just a moment, which is why then my brother sitting in Meru then found that the act of reintroducing another motion was itself contemptuous of that aspect of the ruling. Be that as it may, because I am not a court of appeal.
Yes.
The reason I've also put your time, I've halted your time, is I want to make clear, unless you can make me see that there is something completely outside of what my brother Hassan J and then subsequently Muredi J dealt with, I cannot safely record.
My Lord, foremost,
yes.
My submission is as follows, my Lord.
Yes.
That his order is, the upshot reads as follows. The upshot of the above is that the impeachment process is halted, pending the ruling, and since this is a matter of public interest, the rulings, that is the preliminary objection, interested party, the main petition will be delivered on Monday 29th. So, my Lord, this is an order halting the impeachment process. Our submission in that regard, my Lord, is that the impeachment process that was live before court on that date is the impeachment process premised on the impeachment motion dated 15th of July of 2024. That order, my lord, was not forward-looking.
Yes.
It was not prospective. And my lord, maybe to give you context.
Yes.
If you look at the ruling that was given subsequently on 29th of July by the Brother Justice Kassan,
yes,
at page 310 of our bundle, at paragraph number 3, my lord?
Yes, to defer the ruling.
Yes, the decision to defer the ruling in order to pave way for possible alternative justice system. In Brother Justice Kassan asks, who will be prejudiced? The respondent will not be prejudiced because the ongoing impeachment process will stop. The ongoing impeachment process.
Be that as it may, counsel.
Yes.
Be that as it may.
Yes.
Perhaps you're trying to convince the wrong justice.
Yes.
Perhaps this is something you should be saying in a court above mine. Because you're asking me to interpret what two of my brothers meant with their rulings.
Yes.
Now, I could possibly distinguish.
Yes.
Yeah, I could. And I've not determined one way or the other which way I would do.
Yes.
But is it so clear and stark that what they meant was a specific motion, or the fact that there were impeachment processes? Because I started with Kassan J's penultimate paragraph, where he says there have been previous motions.
Yes, my lord.
Have you canvassed this in your submissions?
I have extensively canvassed the same, my lord.
Okay.
In our replying affidavit, and it's our issue number 1 in our submissions. Though by that time, my lord, the ruling was not been delivered, so it was not brought to our attention. It's a matter, my lord, that we wish to.
That's why I'm saying you've not canvassed it in your submissions, so now I am constrained. And I did mention it. Just a moment. I mentioned it on Friday. Aside from whether or not I can distinguish, there is then the question of what is highlighted. Are we highlighting written submissions that have been filed, or are we now expanding into new territory? In another matter, the abductions case, when there were developments, I had to push back the ruling date so that they could file submissions to cover the developments. There was another case where there had been some developments. So if I let you submit on this,
yes, my lord,
it will be akin to you filing supplementary submissions.
Yes. I think, my lord, these new developments, especially the issue of that ruling, was orchestrated by the petitioner. It is a petitioner in the supplementary submissions who introduced the issue of these rulings. It was a new development. So we did not have an opportunity to respond to that issue because we had already filed our final submissions. But they introduced a new issue in the supplementary submissions. So of course the prejudice, my lord, is on the part of the assembly and the respondents if we do not respond to that issue. And more specifically, my lord, we do not ask you to review or to even distinguish or try to interpret the orders by your brothers. What we ask for you, my lord, is
yes,
not to be persuaded by that ruling.
Council Mutuno,
Yes, Your Lordship.
what do we do?
For us, where we stand, the Lordship, this is a very clear issue that we want to
No, not in terms, don't argue it.
Yes.
What do we do? Do you have a suggestion? Because I have something that is percolating in my mind. I'm hoping that you will have something better than what I'm considering doing.
Your Lordship, we brought the attention of the court.
Yes.
To a ruling that
ruling is part of the legal authorities. The court asked to look at and either be persuaded or adopt it as it is.
Just for clarity, even if you had not filed it, the High Court is deemed to do what every High Court has said. It's a fiction, but I will be deemed to have said that it had been delivered, so I'd have had to at least comment on it. Would you be open to those opposed filing written submissions?
We are not opposed to that at all. They can file written submissions in respect to that one aspect.
That one aspect, only limited to 5 pages. There will be no highlighting of that though, so I'll just have to read it. Because I'm eating into so much of my time I was supposed to have started this on Saturday morning, but now on Monday. If I give you, please sit. If I give you until, what is practical?
Three days of apartment.
Oh no, absolutely. Have you seen the volumes you guys have given me? This has a judgment date of 14th. I was very clear. Short of Kenya being invaded, I am not adding a single day to it. This is not the only one. I have the abductions one as well. I have quite a number of judgments. So I can't give you 3. I have to start this possibly tomorrow, latest on Wednesday.
We can file the close of business tomorrow.
Close of business tomorrow?
Yes.
There will be no rejoinder. It's just they file close of business tomorrow. So may I then suggest that any reference to how I should interpret that, we just leave it for the submissions.
My Lord, if I can just make one point.
Yes.
You see, our position, my Lord, is not that we ask you to review or to appeal on that decision. We understand that these are courts of concurrent jurisdiction.
Yes.
The only way that decision can be overturned is on appeal.
Okay, let me explain where I'm coming from. I was once a member of a tribunal with respect to Justice Marete. And I signed that, it was a unanimous decision, I signed that decision where we disagreed that there was res judicata. The central complaint that JSC found had been substantiated to the level required to recommend to the President was that sitting in one court, he determined something interlocutory that was pending before his sister at MILIMANI. And they found it so grave as to recommend for the formation of a tribunal. So res judicata, this idea that 2 courts can determine the same issue, can be very grave, not just for striking out of pleadings. That's one thing that you can do, or you say this particular part I will skip it somewhere else, but it can also create a peril on the individual judge. So if for no other reason than because I don't want to sit in a place at KICC having to explain my understanding of res judicata, can we agree that you file very, very good written submissions so that if I'm ever called on, I go and say, Michele filed this, Mawira filed this, and they convinced me. Is that fair enough?
My Lord, I can see my colleagues here.
Yes. Yes.
If I may,
yes.
The petitioner got a chance to sort of highlight at length about that issue.
But you can't highlight something I've not read. See, what I want you to do is also bring those authorities. Because you'll have to say, but that's the challenge, I've not read them. For better or for worse, I've actually read all your submissions, so I know if you want me to then give you a date for highlighting, limited to that, and limited to just yourselves, and maybe limited to 15 minutes, one of you, then we can do it that way.
My Lord, we do not want to stretch this because we want to...
You can do it virtually. 15 minutes. But sometimes your submissions are so good that they don't need to be highlighted.
Thank you for that, my Lord.
Yes.
But nonetheless, my Lord, we pray that granted the opportunity to highlight, limited to 15 minutes. I believe we can do
Sorry, my lord.
30 minutes.
My brother's permission. What we got wind of when our colleagues highlighted for 1.5 hours on that issue on Friday is that we felt we also needed to respond, not as per what we put down in writing because we didn't have the chance, but perhaps on points of law and what we feel as lawyers we can be able to tell you as a judge, this is what the law says, but it's upon you to make a decision. To that extent, my lord, I think you should allow us, even if it's 2 minutes, to just tell you what we feel the law says about this particular situation.
You will want to file authorities, or you want to rely on authorities?
Yes. Unfortunately, yes, my lord.
So when you want to file authorities, or rely on authorities, because this is a long authority, and this is one of the problems that we have with authorities, you can quote a paragraph out of context. So I would still have to go and look for it. And with a time-bound judgment date, it's easier for me to front-load that to yourselves, file the authorities, file written submissions limited to 5 pages, then I can see them.
Thank you, Lordship.
Yes.
We have taken note of that, and the authority we intend to ever rely on is the common authority of the Supreme Court of Karaoke, and which our colleagues are well about the duty of society in the area missions. My Lord, I don't think any harm, even for the court, because as you said, we are taken to know that.
Okay, fine. So what I'm hearing is you've declined to file written submissions. I can't...
No, you did get me right.
I can speak for Lord.
Yes.
We are gladly accepting the offer to file written submissions, but also we want to trust the also of those authorities in not more than 10 minutes.
So what then would be the point of filing those submissions?
My Lord, for the comfort of the court, my Lord, I can speak about just 2 points, my Lord, in not more than 3 minutes. Then we file our written submissions, then we highlight, as you suggested, on a virtual court session. I think we will deal with those issues at length virtually. And we're able for you to highlight.
Nema, please give me my dad. And your time has been off this entire time. There's space on Wednesday. So you can file by close of business tomorrow. You come highlight at 9:30 a.m. on Wednesday, and I will still maintain my judgment date of the 14th.
Virtually on the physical court, my Lord?
Let's do it virtually.
Thank you.
Because I have so many others virtually. Jumping in between courts may not work. Okay, so I'll give you very limited time today, but you do file your written submissions by close of business. Tomorrow I will formalize that at the end of today. Yes.
Thank you, my Lord.
Your time is back on.
Thank you, my Lord. The first point, my Lord, that I want to submit on is what you just raised, the issue of the res judicata. My Lord, again, we submit that we are not inviting to review or appeal the decision. That decision, that ruling, for your brother Justice Murithi. And, my Lord, it is a petitioner. If at all, my Lord, that issue was before the court in Meru, the issue of the conservatory order, our position, my Lord, is that the only issue that would be res judicata, if you were to consider it, is the issue of contempt. Because that was the issue that was before your brother in Meru. The issue of contempt, my Lord. such that if you sat and made your own decision on the question of whether there was contempt of court, that would without doubt be res judicata. The question of whether there was a conservatory order or not was not answered by the judge in the affirmative. But even if, let us assume, my lord, that question was answered by the judge. The question is, my lord, would it be proper for the petitioner to canvass that issue in two courts, in two different stations simultaneously? Would that issue have been canvassed in Meru while being canvassed before you at the same time, my lord? That is the question. And our submission in that regard, my lord, is the petitioner cannot benefit from her own mischief. She brought that question for determination before you. That question was not determined by the judge in Meru in the affirmative. He did not, as a matter of fact, say that there was a conservatory order granted on this date, stopping the impeachment motion dated the 1st of July 2024.
Yes.
And therefore, my lord, two options are available to you.
Yes.
The first one, my lord, is to appraise yourself of the evidence, the detailed affidavits, and the submissions of the parties, and arrive at your own independent determination of that question.
Yes.
Totally uninfluenced by that ruling. And two, my lord, if you are to find that indeed this matter was being canvassed in two courts at the same time, then the petitioner is guilty of unclean hands, and she cannot benefit from her own mischief.
Yes.
And as you submitted earlier, my lord, this would indeed be the reason why the Assembly was not joined as a substantive party in the petition before you.
Yes.
In the second instance, my lord, then what you do is to don your tools on that question and fail to determine it all together.
Yes.
Solely for the reason that the petitioner canvassed this issue in two different courts at the same time, my lord.
Do you have a hard copy of that ruling?
I have a hard copy, my lord. Somewhere here.
So I've stopped your time for the active time. Let me read you paragraphs 36 and 37. Clearly, the respondents were in contempt of court to withdraw a notice of impeachment against which orders have been issued by a court, and to introduce a fresh impeachment process outside the one subject of a court proceeding in which the court has made injunctive relief so as to defeat the effect of the court order is similar to withdrawing a suit in which an order restraining certain conduct has been made so as to defeat the said order of court. It is a classical textbook case of disobedience of court orders, albeit in crafty manner. It is gaming the system of the rule of law that binds the three arms of government in mutual respect. I think there's supposed to be an under separation of powers. The deputy leader of the majority, I believe that is the sixth interested party, withdrew the notice of motion for the removal from the office of governor on 30th July 2024 and issued a fresh notice of motion for removal of governor on 31st July 2024. With respect, the court did not purport or pretend to grant, as submitted by the respondents, immunity. I'll not read the rest. I'll just read the last paragraph, the last sentence, sorry, of paragraph 38. When the respondents proceeded with the process of impeachment of the petitioner despite, and indeed in spite of, those orders, the respondents were in clear and mitigated contempt of court. Those words speak for themselves. So I will record what you are saying. I look forward to your written submissions. All that I will caution is, as you're making your submissions, please bear in mind that I have a one is supposed to distinguish matters. You're going to need a lot more authorities. I can think of a few authorities which may or may not apply to this. Really consider whether this is the best use of our time. I've limited you to 5 pages so that parties don't go too far. But you're going to need quite a lot of authorities, because those paragraphs, those 3 paragraphs, are very clear as to what has been determined. Now, whether or not a motion can exist in 2 high courts, that is something you'll raise in your submissions. Whether then I should disregard all that I can record safely now because it's an option for me. But how to characterize what was happening in that court, you may need to get some authorities, because even the mere act of recording it is itself potentially res judicata.
I'm getting recording a lot.
Yes.
And that is why, my Lord, on the part of the assembly,
yes,
and unlike the petitioner,
yes,
we are giving you several options which you can exercise, my Lord.
Yes.
We are not telling you that you are bound by that ruling. Especially because it is the petitioner who brought this issue before you for determination. So
yes,
you have several options, my Lord. You either determine that issue independently based on the evidence.
Yes.
And if indeed you find that that matter was sustained in 2 courts simultaneously, then the petitioner cannot benefit from that mischief.
Now, just a moment, and this time I'll not switch off your time. I can't recall who on Friday stated that there is an appeal that has been lodged in the Court of Appeal, but there are no orders of stay.
That is the correct position.
What then were to happen if I were to determine one way and the Court of Appeal determined another way on the same?
Indeed, my Lord, and that is why, my Lord, we are urging you. Of course, there are other reasons, such as the parliamentary nature of that ruling, and as we well advised, we are going to distinguish it through authorities as we seek to persuade you, my Lord, why you should not be persuaded by that ruling. 1, we are not bound by it. 2, we are urging you, my Lord, not to be persuaded by that ruling on account of its inherent errors, the parliamentary nature of that ruling.
Yes.
Where the county assembly speaker and the other and the mover and the clerk were condemned and hurt. If you check that ruling, my Lord, there are no parties to that case. The court convicted them, my Lord, and proceeded to sentence them without an opportunity at litigation. My Lord, we know that these grounds are going to be made even on appeal as we challenge that decision. But for the moment, we are telling you, my Lord, because of those errors,
yes,
inherent in that ruling, do not be persuaded by that ruling. Even more fundamentally, my Lord, is that this ruling ignores or disregards the binding precedent from the Supreme Court in Justice Kariuki matter.
Yes.
And I believe also there is another decision, my Lord, we are going to put them in your submissions on why in contempt proceedings a party cannot be condemned and hurt. This is what the court did. These parties were condemned and hard. And based on that peculiar nature, my lord, we will be urging you not to be persuaded. But even more fundamentally, my lord, is a question that, given that this matter was brought before you for determination,
yes,
can the petitioner honestly tell you that I brought this matter for determination before you, but I have now obtained a favorable ruling from another court where I simultaneously canvass this issue? Your hands are not tied. You are bound by that ruling. You cannot exercise your discretion on that question. Can the petitioner, in all honesty, tell you that?
yes,
Such that whichever way it goes, my lord, the petitioner cannot be the one to benefit from mischief.
yes.
Now, moving out on that issue is a question whether
20 minutes to go.
My lord, the question whether that ruling that was given in Meru, even assuming, my lord, and this is purely for argument's sake, even assuming that indeed there was a conservatory order, which you pretend there was none, can this court, in exercising its jurisdiction to review the processes at the Senate for violation, to check or to establish whether there was violation of individual rights, find and hold that indeed the petitioner's rights were violated? My lord, the answer to that question is in the Supreme Court decision in Sonko, and we are going to elect it in our submission as well.
Yes.
Sonko, as a matter of fact, had a conservatory order from the Employment and Labor Relations Court.
Yes.
In our case, my lord, there was no conservatory order. But nonetheless, the Supreme Court held that there was no violation of his rights to a fair hearing. So we will be addressing you on that question as well, my lord. The question of that is the place of the conservatory order in these proceedings, and whether the absence or presence of it, my lord, would be said to be violative of the individual rights of the petitioner. My lord, I will address you on the question of whether the threshold for impeachment was met. My lord, as I earlier submitted, this court is not seeking to conduct a merit review of the decision of the Senate.
Yes.
Kenyans, in their own wisdom, arrogated that function to the Senate. But purely out of abundance of caution, my lord,
yes,
and in order to protect the Assembly's interest in this matter, my lord, I will address you on that specific question, and only limited to the question of, one, what is the legal threshold for impeachment? But that is the only question I'm going to address you on, my lord.
yes,
I'll answer, my lord, in response. Is that, my lord, foremost, the impeachment charges as drawn in the impeachment motion. You can see the impeachment motion, my lord, on pages 94 to 121 of our next charge, JK 1 to JK 40. That bundle, my lord.
yes. Pages?
Pages 94 to 121. This is an impeachment motion, my lord, that went to the Senate. And what's the earlier one, the 15?
Yes.
My lord, the impeachment motion, if you read, for instance, the first count, that is count number, gross violation of the Constitution. The test, my lord, is whether the impeachment motion states with specificity the provisions of the Constitution or the law that has been violated. My lord, I believe the document speaks for itself. Various provisions of the law have been quoted. If you go, my lord, to the first allegation on legally revoking the appointment of Virginia, and we turn to the evidence, my lord.
Yes.
And the evidence, my lord, is to be found in Annexure JK 41A to B. At pages 918 to 920, my lord.
Yes.
In fact, all the way from pages 917, my lord, you will see a letter under the hand of the petitioner. It is Annexure JK 41A.
Sorry, my paper's fallen. I'm just a moment. Page 917.
Page 917, page 918, 919 as well, my lord, and 920 to 922. You will see a letter, my lord, under the hand of the governor, the petitioner in this matter,
Yes.
revoking the appointment of Virginia as CEO of Meru County Public Service. This is a matter, my lord, where the petitioner can honestly tell you that there is no direct nexus. It was a matter of collective responsibility. Certainly not. On the next, at page 918, my lord, you will see the advisory that was given by the chairperson of the Meru County Public Service Board, advising the governor
Yes.
that purported revocation was illegal.
Yes.
And at page 920, my lord, you see the response by the governor disregarding that advice. And this, my lord, be said to be a matter of delegated responsibility. My lord, if we turn to, I think I'll point out just a few, my lord, in the interest of time. The third allegation on refusing to implement the recommendations of the Assembly.
Yes.
You will see at page 1056 of the same volume, my lord.
Yes.
The recommendation by the committee to the governor to remove from office these people who the committee had found that the governor had used. So, my lord, even in the case of when the station was, the governor was exercising collective responsibility. At page 1060, my lord, you will see that that report was served on the governor, contrary to what the petitioner's counsel submitted. That letter was served on the chief of staff in the office of the governor at page 1060, my lord. So can the governor properly say she was not aware or this matter was not brought to her attention? To submit, my lord, and the petitioner at all times knew.
Yes.
Further, my lord, there is an authority, I think I saw it in the petitioner's submissions, the authority on, I think it's a Nigerian authority, on what amounts to a gross violation. And it talks about interference with the functions of other bodies.
Yes.
If I remember correctly, my lord. My lord, when the governor, for instance, at the first allegation, it is illegally revoking the appointment of Virginia without a vote of 75% of all members of the county assembly in usurpation of the powers of the county assembly. Is that not interference, my lord, with the functions of other bodies? If you go to allegation number 4, my lord,
yes,
illegally dismissing Dr. Antoniti, Paul Mwaki, and others, the operative words, my lord, are in the usurpation of the powers of the appointing authorities. Is this not interference, my lord?
yes,
Article 79 of the Constitution, my lord, on breach of public trust, would also come. I think it's one of the provisions that was put in Martin Nero and Bora. When you retire, my lord, you look at it. In the interest of time, I will not go to that. Breach of Article 75 on public trust is enough to establish, and even Article 10, my lord, it is enough to establish gross violation.
You have 5 minutes.
Now, on the last issue on public participation, before I yield the floor to my young colleague, Mr. Alex, Mr. Mbaya, my Lord, the County Assembly conducted comprehensive and adequate public participation. When you retire, my Lord, you will consider the public participation report that I am holding in my hands. It was a 44-page document in the JK Annex, JK 41E. It contains the public participation report.
How many pages?
1344 pages, my Lord.
Yes.
It has several annexures. And as you will note, my Lord, this document was equally served upon the governor, but she never responded to it at the assembly. The public participation report has attendance sheets for the various public participation forums.
Yes.
There are minutes for the meetings, my Lord. There are registers and memoranda in support and opposition to the impeachment motion. My Lord, the County Assembly prepared a public participation schedule, which is on page 2061 to 2062. It was published on the Sunday, on the Daily Nation and the Standard on the 1st of August of 2024. And our public participation schedule, my Lord,
published in
the Standard and Daily Nation of 1st of August 2024. It listed the venues for the public participation meetings that were to be held on 5th of August, that is 4 days ahead. It also provided, my Lord, that written submissions would be undelivered to the office of the clerk. It could be sent by a post to the postal address of the County Assembly, or sent by email to the email of the County Assembly. It was equally published, my Lord, on the County Assembly website, and persons desiring to see the public impeachment motion will download it from the website. If you turn to the next page, my Lord, on page 2063,
yes,
you will see the invoice from the local radio and TV station, where they are on advert for 3 days. My Lord, in summation, the public participation exercise was carried on from the 1st July, when the schedule was posted on the County Assembly website, until 5th of August. There was widespread advertising, my Lord. And the Assembly, my Lord, satisfied the test in facilitating, because the test, my Lord, as we are told by the Supreme Court in the Finance Bill decision, it is somewhere in the submissions, my Lord. The test is where the county, the legislative body or assembly, facilitated the public participation meeting or public participation exercise, my Lord. You will note that, my Lord, the county assembly employed various modes. And, my Lord, given the strict timelines, the 10 days, yes, the county assembly has up to 10 days to consider from approval of the motion to tabling to the notice and to the disposal, up to 10 days, my Lord. The county assembly has up to 10 days to consider the motion. And they undertook public participation for 5 days, for half of that period. The public participation exercise, my Lord, was therefore comprehensive, it was adequate, and it met the requisite test, my Lord. On the last, just 2 minutes, my Lord, if I may, on the issue of fair hearing,
yes,
the petitioner was a respondent who was invited, my Lord, to appear before the assembly by the letter dated at the 1st of August, of July, my Lord, I'm sorry, of July 2024. It is somewhere in our volume, in our JK41 A to B. My Lord, the petitioner did not appear before the assembly.
yes,
As the advice admitted, she was equally served to the public participation report, to which she never responded to. And the Senate, my Lord, and that is the remit of this court, In reviewing the procedure of the Senate, my lord, you will note from the answer, there is a hearing program, my lord, in our documents. We equally have the rules of procedure that was served, the invitation by the Senate to the parties. The petitioner had ample time to make an opening statement, to examine our own witnesses. She appeared personally as a witness. Her counsel had ample opportunity to cross-examine the Assembly's witnesses. Senators had ample opportunity, my lord, to seek clarifications and indeed to ask questions from parties and their counsel, their respective counsel. The petitioner and the Assembly had 1 hour each, 60 minutes each, to make closing arguments, closing statements. And therefore, my lord, the petitioner, my lord, was afforded an ample opportunity to present our case and to plug holes in the Assembly's case before Senate would make its resolution, my lord. We will take guidance, my lord, from the division in Sonko.
Yes, you have 1 minute.
From the decision, we will take guidance, my lord, from the decision in Sonko on that issue, my lord. And also on the issue of public participation, my lord, where the Nairobi County Assembly undertook public participation, but was not even as thorough as the one by the County Assembly of Meru. The Supreme Court held, my lord, found that at paragraph 134, the procedure and understanding order appears to have been meticulously followed. I believe, my lord, from paragraph 130
yes,
up to 139, my lord, the Supreme Court finds that the appellant was afforded ample time and opportunity, my lord. We will equally be urging him, my lord, to be persuaded by that binding authority, my lord, where the Senate and the County Assembly of Nairobi undertook measures that were not as thorough as the ones in the County Assembly of Nairobi. I will now yield the floor to my colleague, Alex. Thank you, my lord.
Still for the 5th?
Yes, my lord.
But your time is up.
That will be going for 15 minutes.
We had scheduled a health break at 4, so let's take 20 minutes and then you can have some time. Can I give you 10 minutes? Okay, I'll give you the 15 minutes. So let's reconvene at, should we take 20 or 30 minutes? Okay, let's take 30 minutes. So we'll reconvene at 16:30 sharp.